Good morning, good afternoon, good evening, and welcome everybody to our webinar on Ecocide, Legal Revolution or Symbolism, co-hosted by the Institute for International Law of Peace and Armed Conflict, the Graduate Institute in Geneva, and ESIL's interest group on human rights law. I am Jan-Phillip Graf, a PhD candidate in international law at Bochum University, and together with my colleague Romina Pezzot, PhD student in international law at the Graduate Institute in Geneva, we will moderate today's webinar. We are extremely glad to have received over 500 registrations, which only attests to the legal importance of the topic we are going to discuss today. Likewise, we are happy to see so many familiar names of our valued colleagues, friends, and mentors among the participants. In particular, we would like to thank Professor Pierre Thielberger, the co-convener of ESIL's interest group on international human rights law, for his exceptional support and assistance in setting up this webinar. We would also like to warmly welcome our highly distinguished panel, Philippe Sands, who is a professor of the public understanding of law at UCL and visiting professor at Harvard Law, Paola Gaeta, who is a professor of international law at the Graduate Institute in Geneva, Kai Ambos, who is the chair for criminal law, criminal procedure, comparative law, international criminal law and public international law at the Faculty of Law at Georg August Universität Göttingen, and of course, Jorge Viñuales, who is the Harold Samuel Professor of Law and Environmental Policy at the University of Cambridge. This is the kind of panel which hardly needs an introduction, and we are grateful that you are joining us today to discuss a very recent development in international law, which has even received a lot of attention outside of our discipline.
Thanks, JP, for your introduction, and hello from me as well from the other side, from Geneva. And well, the objective of this webinar is to discuss about the recently proposed new definition of the crime of ecocide. And we think it's important to remember that the term ecocide did not emerge this year. On the contrary, in 1970, Arthur Galston, he was an American biologist and activist against the Vietnam War. And in that year, he used for the first time the term to make reference to the harm that it was being inflicted by the American troops upon the Vietnam forest by deplosion and bombing. So also in that decade, especially in 1972, another professor, Professor Richard Falk, he wrote a paper where he proposed the adoption of an international convention on the crime of ecocide. So since then, this seed about criminalizing the harm to the environment was planted in the international community, unfortunately without much success. Perhaps we can take into account and remember the works of the ILC, the International Law Commission, on state responsibility for international wrongful acts, and also the Rough Code of Crimes against the Peace and Security of Mankind, where harm to the environment was included in the early documents of these works as a crime, and finally, in the last version, it was excluded. But fortunately, the Stop Ecocide Foundation, an NGO that is working for the recognition and adoption of the crime of ecocide by states, proposed and invited experts to be part of the independent expert panel for the legal definition of ecocide. And this expert panel this year finally proposed an amendment of the International Criminal Court Statute. And if finally this proposal and this amendment is accepted by the Assembly of the State Party, we will have a fifth international crime that eventually the ICC can have jurisdiction. So in this document that was published in June of this year, the expert panel proposed this definition that it says, ecocide is an unlawful wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts.
This new definition initially received a lot of largely favorable attention from news outlets all around the world, with The Guardian speaking about a historic definition and a crucial step towards adding ecocide to the list of other major offenses recognized by the International Criminal Court. The Financial Times was also enthusiastic, writing, for instance, action on climate change clearly isn't radical anymore. It's mainstream, required by law, and increasingly demanded by the population. Meanwhile, in the legal blogosphere, the reaction was somewhat more nuanced, so to say. While Emma O'Brien concluded on Eagle Talk that criminalizing ecocide in international law would send a powerful message about our collective priorities, others raised some points of concern or outright criticism. Kai Ambos, whom we are fortunate enough to have on our panel today, argued in another post on Eagle Talk that apart from the technical shortcomings of the proposed ecocide definition, it was doubtful whether a new standalone core crime is needed to better protect the environment. Kevin John Heller even wrote 3 related posts on Opinio Juris criticizing several elements of the definition, partly in response to a lively debate on Twitter, which had ensued there.
Okay, so before moving forward with the questions to all the speakers, we would like to start with Professor Philippe Sands, taking advantage that he was one of the co-chairs of the expert panel. So we would like to know from him and have some details about the backstage of this document and this proposed definition, taking into account that it was a small group integrated by lawyers with different background and expertise. At the same time, you had to work in a short period of time during 6 months. So for sure, it was a big and difficult job. So if you can tell us about this backstage, or for example, which were the challenges that you had to face. And also, for example, I remember that in the document, it's mentioned that the expert panel thinks that the proposed definition is practical and effective. So if you could can tell us and give your perspective about this, it would be awesome. So Philippe, you have the floor. Thank you.
Thank you, Romina, and thank you, Jan-Phillip. It's incredibly nice to be here with other colleagues. And can I just begin at the outset by saying, those of you who know me, Paola, Jorge, others, I love being criticized. I'm totally in favor of open expression. We're all going in the same direction. We're struggling to just work out what's the best way to do it. So please, as you make your comments, I'm the most thick-skinned person in the world. I love being told I'm wrong, I've screwed up, I've got it wrong. We're just having an academic conversation here to try to do the best. And that's the spirit in which I participate. I'm not defending any particular view or any particular definition. I happen to be supportive of the definition, but I'm open to recognizing there are many improvements that could be made. That's the spirit of this excellent conversation. And again, the numbers, I think, don't surprise me. I literally get 3 or 4 emails every day. And I could do 2 or 3 newspaper interviews a day on the subject of ecocide. It seems to have caught the public spirit, and that makes me happy, because just to put my cards right on the table, at the end of the day, there is a part of me that thinks it doesn't really matter what the definition is exactly. This is about shifting consciousness. This is about moving away from a set of 4 international crimes, which are wholly 100% anthropocentric. This is about effecting what is a revolutionary shift to recognize in international criminal law that it's not all about the human being. And that's what I care about most fundamentally. The single best law review article I've ever read was back in the 1980s. It remains the case, by Christopher Stone. Many of you will know it. Should Trees Have Standing? The seminal article he published in the University of Southern California Law Review, which challenges so many of our basic precepts about the legal order, the international legal order, humankind's relationship to the natural environment. So I have not got a long history in ecocide. I was not involved until October, November 2020. I have not been involved in Polly Higgins and Jojo Mehta's efforts. I watched, I observed, I wondered whether the time was right. And then out of the blue, I received an invitation to join a working group, which I then had the privilege of co-chairing with Diafalo Sal, a very distinguished Senegalese lawyer who I would have on this conversation, save that she only speaks in French, and that makes communications a little more difficult and slower when you've got an Anglo-Saxon or an English-speaking conversation. But she was very much the co-chair, extremely active, and we worked very well together. I think they came to me because my interests straddle the environment and international criminal law. I started off with the environment. My first real research of my own was on Chernobyl and the legal consequences, and that led me to write my first big book on international environmental law back in 1993, and I've taught the subject ever since and remain very involved in it and very active also, as some of you will know, in international cases at the International Court of Justice and other places. So I have an interest in the environment that's long-standing. And then more recently, working with Andrew Clapham at Rome in 1998, we were part of the delegations of the South Pacific Island states drafting the statute of the International Criminal Court. I don't think it's widely known, but Andrew and I actually drafted the whole of the preamble. We were astonished to come up with a text that no one changed. It says a lot about the hopelessness of international legislative processes, that two teenage kids, as we then were, can do such a thing. And we put things in it that were very mischievous about the duty to investigate and prosecute, totally new stuff. No one changed it, and it unbelievably made its way into the text. And of course, 10 years after that, I got an invitation to go to Lviv to give a lecture on the cases that I've done on crimes against humanity and genocide in my practice as a barrister. It happened to be the city where my grandfather was born, Lemberg, Lviv, Leopolis, Lvov, and I went and unbelievably stumbled by accident across the fact that that city was the origins of crimes against humanity and genocide, as reflected in my book East-West Street. So there was a sort of happy convergence that came together, and I accepted. And it was very interesting. When I accepted, The Guardian did a little note just saying there's this new working group, blah, blah, blah. And I have 3 kids, all in their 20s, who I'm very, very close to, and who, you know, follow roughly what I get up to. I think sometimes some interesting stuff, the Rohingya, the Yazidi, I mean, not boring stuff, I think. This was the first time, it was interesting, that all 3 of them got in touch with a WhatsApp and said, oh, Dad, finally you're doing something useful and interesting. And I thought that said a lot. I thought it said a lot generationally about what people care about. The fact you've got so many people on this Zoom webinar, I think reflects that. So there was a happy convergence. I wanted the group to be balanced, and it was balanced. You can go through the membership. You've got, I mean, not in a party political sense, but, you know, fundies and realos. You've got ecological activists, and you've got former US federal prosecutor and ICC prosecutor. You've got a real mix of characters. And in that context, what was very important for me was to have a consensus. We all know, I sit on arbitrations, that if you can have a consensus, warts and all, everyone makes concessions, it's better than a divided report. That was absolutely crucial for me. And it meant that everyone had to give way in some respects. And that is, I think, of course, whatever comes next, what will happen also when states get together. There is no perfect right definition of ecocide. I disagree fundamentally with Kai. The existing 4 international crimes are not sufficient. They are anthropocentric. I, over the last few days, like many others, no doubt, have had many requests to sign on to various complaints about President Bolsonaro and destruction in the Amazon rainforest. No, it's not a crime against humanity, and you can't fit it in to a crime against humanity. But even more than that, if you try to fit it into a crime against humanity, you immediately make it not about the environment as an end in itself, but the environment as a means to protect human beings. And that's the central point. That's what we have to get away from. And that's reflected in the definition. Make damage to the environment of itself something that is to be criminalized. Why the criminal law? The group was very, very clear about this. There were 4 existing international crimes. They all date back to 1945. 3 of them were invented in 45. There have been no new international crimes since then. There's been tweaking, rape as an act of genocide and various bits and bobs, but basically we've done nothing new in 75 years. And it's time to be new. There was no international environmental law then, or indeed until the 1990s. And this, in a sense, just brings international criminal law up to date, and no doubt is already behind the curve in terms of where things go. The law, and international law in particular, never leads. It always follows. And that is a challenge, I think, that we all have. Let me talk a little bit about the process. We all agreed we wanted a consensus. It was a very deliberative process. We met about once a month for long afternoon, or did it all by Zoom. We've never met in person. It was very balanced in terms of backgrounds, gender, political orientations, activisms, legal qualities and skills, and that made it interesting and exciting. It was an amazing intellectual challenge to be part of it, starting with a clean slate. And I have to say that I constantly had in the forefront of my mind the experiences of those 2 remarkable individuals, Hirsch Lauterpacht and Raphael Lemkin, 42, 43, 44, when they started more or less with a blank slate. There'd, of course, been developments earlier, but in terms of defining new crimes, it is a really interesting thing to go through. And let me just say right at the outset, given the response, which is not only the public response, but the private response, I have no doubt there will be a crime of ecocide, and it will make its way onto the statute of the International Criminal Court. The only question is when. Is it in 5 years? Is it in 20 years? Is it in 30 years? The responses from behind the scenes in particular show me that states will be on board for this, and whether it is a variation of this definition or some completely different definition, let us wait and see. Now, in my introduction, which I'll be brief about, I'm not going to get into the minutiae of the mens rea and certain other things, because I suspect in the conversations, we will talk about that. But needless to say, there is not a word or a comma or a semicolon that was not hotly debated, be assured. And it was in that spirit of working a consensus that there were trade-offs as we went along. Let me just make a couple of broad points. One, should we have a list of acts that could be included? This has been one of the criticisms. And the answer to that is, in my view, and in the view of in my view, resoundingly, about 1/3 of the group felt very strongly there must be a list of acts. 1/3 could live with a list of acts, and 1/3 said absolutely no acts. I have to say I was in the list of the group of no list of acts. Why? Because in my experience, once you include a list, you exclude certain other things, and the signal that you send is that all those unlisted acts are fine. I didn't want to do that. Secondly, and this is really driven from practical experience appearing before courts. Secondly, I knew that the moment there was a list, the project was dead, because you could not have a list without climate change. And the moment you put climate change explicitly in the definition, it is dead. Having been at Rio in 92 and in Geneva in 89 and 90 and negotiated the UN Framework Convention on Climate Change, the idea that states, having spent 30 years struggling to address climate change, in an instance are going to accept the criminalization of certain acts that cause climate change explicitly is a nonsense. It's not going to happen. The moment you put climate change in the definition, it's dead on arrival. It will not fly. It must be for prosecutors and judges in due course to decide whether in a particular factual circumstance, an act related to climate change or biodiversity loss or other things is criminalized as ecocide or something else, not for the legislators at this point, because you'll never get a consensus on that. The point is very simple. Each of us contributes to climate change. Does that make each of us écocidaires in relation to climate change? Possibly, some far-reaching people would say, probably not. Most reasonable people would say. And the question is, where do you draw the line? And that's a really tough question. And I think we felt our task was to set out the sort of the fundamentals, and this is the second main point that I will put. I have now lived in the world of international law for nearly 40 years, recognize this to be an inherently conservative field. If you cannot ground a definition in what has come before, it's dead. And so, of course, we took the scraps that were there, the 1977 NMOD Convention, some of the cases at the International Court of Justice or elsewhere that touched on definitions. And we basically were like seamstresses. We were sewing together the bits and bobs that came before, so that for every part of our definition, if someone asked us, we could say, oh yes, we can point you to this international convention which has entered into force, because we knew that that's how legal advisors in states work. The moment you can say to them, well, we've just drawn from another convention, your task becomes a lot easier. But of course, it was a limitative process, which brings me to my third point. I think in the end, we were driven by a fundamental principle, and it is this, and it's a principle also that drives me, ultimately a rather pragmatic person. Less is more. The best is the enemy of the good. I've read with huge interest and also a great deal of amusement many of the criticisms, many of which are very well founded. But you have to ask yourself the question, do we want a definition of ecocide that could run or not? Absolutely, we can come up with a more perfect set of definitions, but it's unlikely to get through. And you have to decide as a scholar, as an activist, as a lawyer, as a government legal advisor, what's the purpose here? And I can only speak for my purpose, and others in the group had different purposes. My purpose was to come up with a definition in which the day after it came out, I would get private emails from government legal advisors saying, you know what, warts and all, it's not perfect, but we can run with this. And that's exactly what happened, which is why a debate has been catalyzed, which is why it brought great happiness to me when the Financial Times and the Wall Street Journal, not bastions of progressive thought on these kinds of issues, wrote incredibly favorable pieces. If you can get those folks writing pieces like that, you've got a chance of effecting a change. I remember now, and I don't remember, I know very well, the kind of reaction Lemkin got in 44 and in 45. He was trashed. He was trashed by critiques along the lines of those that were mentioned by Jan-Phillip and Romina at the beginning. But he persisted. And he persisted because for him, warts and all, it was better to get something into the Nuremberg indictment and better to get something adopted by convention than nothing at all. Now, reasonable people can disagree. I have myself made the argument that in certain respects, the Convention on the Prevention and Punishment of Genocide could be said to have done more harm than good, to have given rise to the concretization of group identity and caused the very thing it was intended to prevent from happening. These are really complex issues that take us beyond the legal community. But on balance, I think the world is a better place for a definition of genocide that we have than no definition at all. Standing at the International Court of Justice in December 2019 with Aung San Suu Kyi about 3 meters away from me, arguing that Myanmar had committed a genocide in relation to the Rohingya community, having her in court, having to defend what her then government was doing, was, I thought, worth an imperfect definition. And that, I think, reflects the issues that went on. At the end of the day, we got a consensus. Let me stop there, and very happy of course, to listen to everyone else on the panel, but I think set out there the sense of what I wanted to achieve at this point. Thank you so much for inviting me.
Thank you so much, Philippe, for starting us off and for providing us with these interesting insights behind the curtain of the expert panel. And I personally think the process is quite exceptional in a lot of regards. It was, first of all, super fast. It was also outside of, for instance, established international law mechanisms such as the International Law Commission. And also the product you produced looks different than the usual reports or draft articles or draft conclusions we receive from the ILC. I think I basically take away two important observations from your statement. One being that the definition the independent expert panel published is only a starting point in a process which is beginning right now. And the second point would be that any definition in international law, including, of course, the definitions of ecocide and genocide and so forth, are inherently imperfect. But sometimes it's better to have something which is imperfect than something, that never really realizes, which is probably also a thing PhD students should keep in mind about their dissertations. For the second part of our webinar, we would like to engage in a moderated Q&A with all the experts on our panel. And I would like to remind the audience that it's also possible for you to pose questions in the Q&A function, and we will get to them eventually. But for now, I would like to pose a more general question, perhaps starting with Professor Viñuales, who's joining us from The Hague today. And my very basic question would be, Professor Viñuales, whether you think we need international criminal law or an international crime, so to say, to protect the environment? Or do you think general international law, principles of international environmental law are sufficient to do that job?
Thanks, Jan-Philippe, and thanks, Romina, for the invitation. It's great to be here virtually. I think the short answer is yes. I think the short answer is yes. That's the short answer, because a longer answer would require, I would need to say why. And the why is not an empirical why. So I'm not expecting a definition of ecocide, even if it's integrated eventually in the Rome Statute. I'm not expecting to be a powerful sword in its actual application to this case, that case, and that case. I'm expecting it to be a very powerful sword in setting a red line and saying, up to here, you're really risking in your behavior. So it's the metaphor that I tend to use is when you're learning to fly a plane. At some point, someone takes you to a fly, and the instructor turns off one engine on the other side. And the point, you knew the point because you were learning that the plane can fly with just one engine. But now that you're there and the engine is turned off, one of the two, and you keep flying and it works, the realization is much deeper. And I think that the definition of ecocide would play that role. So it would achieve a realization that is much, much deeper than what a customary principle such as a prevention principle could achieve.
Thank you very much, Professor Viñuales, for your reflective answer. I don't know, but perhaps I have a feeling that some other members of the panel might have a slightly different assessment. And I'm particularly looking towards Professor Ambos, whether he shares your opinion about an international crime of ecocide.
Well, thanks for the invitation, and it's a great honor to be here. I'm actually a great admirer of Philippe Sands in terms of his historical work, and especially being German in terms of his work and his films. I enjoyed a lot on certain national socialists. So Philippe, I want to congratulate you personally on this. Having said that, I still disagree with him as to the matter in front of us. I think we have to distinguish three levels here to be a bit more nuanced and a bit more systematic. One level is the policy question, if we need such a thing, call it a crime, an international crime or whatever. So what can criminal law do? And I would be, being a criminal lawyer and also a practitioner, much more skeptical. And I would need much more empirical evidence that there is something like deterrence and even more a kind of positive general prevention, which is expressed in the draft. You know, that now our moral values are reinforced since we have this crime. That's called symbolic criminal law. So I'm much more skeptical, and especially because we have environmental law all over the place, and also environmental criminal law at the domestic level. In my country, for example, Mr. Graf will know it, also is someone younger than me. When I studied, we didn't have criminal environmental law in our penal code. And then now it's a full section on environmental criminal law. So we did things 30, 40, 60 years, 50 years ago, which now are criminalized. And this happens all over the world. So domestic criminal law certainly has increased. And here the question would be, and that could be empirically investigated, how efficient is it to better protect the environment? The second level is the level of the forum. You know, where do we want to have this crime included? I mean, I think it was too much focused, the discussion and in the draft, on the ICC. I think the ICC is in a deep crisis. I think the ICC is heavily overloaded with the 4 crimes it has. We had other proposals by countries with a very, let's say, questionable interest, for example, to include drug trafficking or terrorism. So you should be very careful. You could destroy the ICC with adding a further 5th, 6th, or 7th crime. Also, I recognize, and I agree with Philippe Sands and the group. Last week, I discussed with Charles and with Kate about this in the ASIL forum, that there is a gap in the ICC statute. That's not the point, Philippe. Of course, the 4 crimes are not covering what you cover with your definition, because they are not just environmental crimes. We have a specific war crime, and we can, with certain tricks, subsume certain behaviors under crimes against humanity. But it's much easier to have a specific crime on the environment. I agree. But the question is if the ICC is the right body. And I fear that it will be rather doing damage to the ICC. And my third level would be the nitty-gritty of the definition, where we may have no time to go into. And here I totally agree. I mean, drafting is a hard job, and it's much easier to criticize drafters than to do the draft in the first place. So I would be much more, let's say, much less critical in this regard. There are some technical issues, but this can be solved. So maybe we should concentrate on the first 2 topics. Thanks.
Thank you so much, Professor Ambos, and also for bringing up the role of the domestic judicial system, because indeed that was one of the first things I thought when I saw the ecocide definition earlier this year. But we already have this in our penal code, and it's being litigated all the time. Of course, Philippe, we will give you the chance to respond in due course. But before that, I think it might make sense to ask Paola perhaps to give her view or her opinion on the necessity of an international crime of ecocide, perhaps complementing domestic penal law. And you may also, if you want to, respond to what Professor Ambos has just said.
Thank you so much, Jean-Philippe. Well, my view is that, I mean, I understand the concerns of Kai, because he says, well, we have environmental crimes in domestic law. Why do we need to add an international crime to the long list? But if I can see things from a different perspective, I think that is important that we underline what we could call the expressivist function of international criminal law, which is, of course, to complement through international criminal law rules, let's say, the enforcement of other public international law rules. So let me explain better. If you think of the current international crimes that we have, core crimes, at least within the jurisdiction of the ICC, we know that their pedigree varies a lot. So we have the traditional war crimes, which was the traditional category enforcing serious violations of international, let's say, laws of war, international humanitarian law. Then the novelties of Nuremberg, where, as we know, crimes against humanity and crimes against peace, that they pertain to the enforcement through criminal sanctions of two important bulk of rules of international law, namely human rights law and rights of minorities and groups through crimes against humanity, and jus ad bellum through the prohibition of the crime of aggression. Now, the missing piece in nowadays is environmental law, international environmental law. That, of course, was the concern also of the International Law Commission when in the 70s, AGO proposed to focus on at least the state criminality, since we were not having much more advances on international criminal law because of the Cold War. As you might remember, the massive pollution of the environment was one of the so-called state crimes, because of course in the 70s environmental law started to be a great concern, as we know and we have seen. So I very much believe that it's time, and time is ripe, to enforce the values that international law also protects together with domestic criminal law through international criminal law rules, not because it will be more effective than domestic law, not necessarily, as Jorge has said, but it will have an important expressivist functions. And then also we shall also consider that even without crimes against humanity in international law, we can still punish certain acts because they constitute violations even of domestic criminal codes. But nonetheless, you want to put this famous red light that Jorge was mentioning. So I would think that taking seriously into account the violations of the harm caused to the environment is important job to be done also at the level of international criminal law. So this is my view. Then I don't know whether or not I mean, I tend to share with Kai the view that perhaps the ICC is a bit limited, but I understand that one has to start somewhere. I mean, at least including an ecocide crime within the statute of the International Criminal Court would be very important for what it will be triggering after that. So I think that, I mean, perfectly agree with Kai that the ICC is a big crisis of identity, but I mean, why not? And then we can share views about the nitty-gritty of the definition. So I don't know if I made myself clear on this point, but certainly I would favor taking the environment, the protection of the environment seriously into account through criminal law. But if I can say something, sorry, that otherwise I will forget. I was hearing, Philippe, the question of the acts to be included in the definition, but perhaps it's not the time to address this matter. I leave it aside. We can address it later. Sorry.
Okay, thank you so much for your answers and for sharing your thoughts. It's interesting to see that the three of you shared the idea about the necessity of having an ecocide crime, although you are skeptical about how to do it, which is the best way, about the deterrence effects of criminal law and about doing it in the field of international criminal court. But it's interesting at least this kind of agreement. So I would like to move forward with the second question that is related with, or it's about the aligning international environmental law with the crime of ecocide. So I would like to transmit this question to perhaps we can start with Jorge and then follow with Philippe. And so if we have in mind that international environmental law tries to find a balance between sustainable development and also protecting the environment. So how can the prevention principle and this notion of sustainable development can be present in a definition of ecocide? Thank you.
Thanks, Romina. Yeah, that's, I think, my main criticism in the definition, and I very much expect that Philippe will be able to tell us that it was the result of a compromise. The main problem of international environmental law is precisely that it's overall, with some exceptions here and there, but overall structured as the law of negative externalities. So first, you have the law of transactions, So whether it is production, trade, investment, whatever you, but first you organize a transaction, which is deemed almost, it is almost assumed to be desirable. And then you organize around a sort of a surrounding layer of law that tries to minimize the negative externality without interfering with the very possibility of the transaction. There are exceptions, moratorium on commercial whaling, a few exceptions here and there, but that's how environmental law has been built historically. And that is that problem, which is the fact that you have the two, and in practice, the transaction tends to prevail over the regulation of the externality, that is still there in the definition. And it's not just a matter of anthropocentrism or ecocentrism. You can be, I mean, it's where you draw the line. Given the fact that this definition is so powerful at the level of, at the symbolic level, and it's its main function, I would say. I think that line has to be drawn not better. So I'm not saying that you can politically expect that dimension will not pop up. It's certainly going to pop up. Sustainable development is still with us, and it's still the concept that everyone is using, particularly in developing countries, because it doesn't mean anything. And that's its main advantage. That's its main advantage, which is a federating concept. Now, if that ambiguity is taken to the heart of a stark normative stance taken in the definition of a crime, then it becomes a problem. So I think that it would be fairly simple just to remove that sort of balancing and expect that a judge or a prosecutor will draw that balancing implicitly, but just to remove it, because then the stance is not clear.
Thank you, Jorge. Philippe, would you like to answer to these comments?
Sure. No, it's really interesting, and as Jorge rightly says, I mean, it's really complex. Maybe the best I can do is just share what our thinking was in putting in all these qualifiers. I mean, it was relatively straightforward to come up with environmental damage that is severe, widespread, or long-term. There was debate about the ands and the ors, cumulative or separate. Fine, but that was relatively straightforward. The challenge was that it wasn't enough. And this, I think, came in particular from those in the group, and they persuaded the rest of the group, who had actually prosecuted international criminal cases. You know, people who'd been prosecutors or worked in prosecution teams and said, look, you've got to have a second qualifier. This may or may not be the right set of second qualifiers, but otherwise you put in the hands of the prosecutor an endless category of cases which on their face are problematic. How do you raise the threshold? One, to limit the exercise of jurisdiction to those situations where really only the international is implicated. And secondly, and Jorge has alluded to this, and I'm with you, Jorge, there is a problem. Because the reality is that this definition, or a definition, or some view, won't go through unless developing countries support it. And we have a structural problem in our international society, such as it is, which is that different countries are at different stages of economic development. And definitions you come up with here can have the effect in one country like the United Kingdom, which regulates its forests and so on and so forth, not having much of an impact, but in another country, which is at a different stage of its economic development, bring it to an end and impose on that country legal obligations at the international level, which frees its state of economic development at a much lower level. This is a political problem, it's not a legal problem. The law has to take account of that reality. So the qualifiers that we put in, and they're far from perfect, believe you me, I completely accept that. Unlawful was one threshold. If it violates, and we didn't specify national or international, and that is purposeful. Neither is sufficient. The two together are plainly not adequate. And just because it's lawful can't make it not criminal. So we had to put in another qualifier, and that's the qualifier where the rubber hits the road. We needed to find a way of saying that even if it's lawful under domestic law and unregulated under international law, it could nevertheless be criminalized. And there we came up with wanton. And this has exposed us to criticism, and I recognize that, and I recognize the validity of the criticism. Wanton means with reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. And that is the heart of the matter. If we want developing countries on board, we are going to have to find a way to cut them some slack. I do a lot of work with the developing world. Welcome to the real world. I don't know how you do it. I'm really open to lots of other ideas. There's no doubt Jorge, Paola, Kai, better ways of doing it. But in the time available, that was the best we could come up with. What I would say is I'm delighted there is a debate about this, because there has to be a debate about this. I have to be able to go to the developing countries that I work with in Africa, in parts of Asia, and say, look, Prime Minister, this is why you can support this. And when the Prime Minister turns to you and says, I can't support it because it's going to stop my economic development in relation to this marine area or this or that, we need to have an answer for that. And that's what makes this different from genocide and crimes against humanity. And we can either close our eyes to it, as some in the group wanted to do, and just say, no, get rid of all of this and make it pure environmental protection. And that's fine. I really understand that. But if you open that door, you will lose. You know, there are, what, 123 states parties to the ICC. You need 80 on board to run with this. So it's a realpolitik, but I accept Jorge's point. Can I just make one point in relation to Kai? I also recognize, of course, there will be alternative ways of doing this. You could deal with it at the national level, but that's going to take decades, if not more. You could have an international convention, but states aren't even willing to proceed with a convention on the prevention and punishment of crimes against humanity. It's stuck at the General Assembly. And so I think the model, the only model, warts and all, and I'm not saying I disagree with you, Kai, about the current state of the International Criminal Court, is this is a way of jump-starting the debate and getting it up and running. And there is a model for that, of course. This is how genocide happened. It didn't start at the national level. It started in the summer of '45 in London, when Lemkin failed to get the concept of genocide into the statute, and he then flew himself to deal with the indictment. There are other ways of doing it, absolutely. And I think the crucial question at the end of the day is whether we want this or not. If we want it, we're going to have to make concessions. And the question is, which concessions are we willing to live with? And to take Jorge's thing, what are the red lines we're not going to cross? And reasonable people can disagree about that. I completely accept that.
Thanks to both of you for sharing your thoughts. So I would like to know the opinion of Paola and Kai about this key feature of international environmental law about sustainable development, and what about including lawful or unlawful acts in an eventual definition. So what do you think? I don't know who of you would like to start giving a feedback.
If I may, I mean, sure. Because then Kai can, of course, follow with me. There are two issues indeed. Thank you very much, Philippe, for clarification on the wanton, because this was the thing that disturbed me in reading the definition and the explanation of the definition, particularly because having in mind the proportionality rule for war crimes in conduct of hostilities. The proportionality rules that is framed in very loose terms, and the difficulties for prosecutions to prove that the military necessity anticipated was clearly excessive, etc., etc. I mean, I was a bit disturbed. But I understand that this can be perhaps worked out a bit to make it less difficult, because I mean, if you introduce it and then you make it impossible to be prosecuted, then what's the point? I mean, I understand that still there will be the powerful expressivist function of having ecocide, but at the same time, you want to have some prosecution being successful. But I understand and accept the explanation. On the contrary, when it comes to the unlawfulness that you explained today, but also in the commentaries, that unlawful acts as the actus reus of ecocide may encompass also violations of domestic law that are not necessarily international law violations. I have some hesitations. So on the one hand, I agree that it's better not to have a long list or a list at all. Similarly to war crimes at the beginning, because for war crimes, there is, as we know, the Nuremberg tribunals and following tribunals, with the exception of the Rome Statute, said violations of the laws on warfare, full stop, with some examples, and that's it. And anytime you make a list, in particular with war crimes and the Rome Statute, you may get the impression that the use of chemical weapons is fine, or nuclear weapons is fine. I mean, when you do the selection, then I agree with you totally. But what I find complicated, in particular, if this is combined with the jurisdiction of the ICC, how can you link, let's say, the jurisdiction of an international tribunal on an international crime that has to take into account criminal law of each country, to identify whether or not there is a criminal act, in particular because this will create inequalities. So if a more advanced country would have made some more advanced environmental criminal law acts in national law, in some other countries will be not like that. So you might have someone prosecuted and convicted for an act that is criminal under its domestic law by the ICC, but not punished the same act for another individual because it's not criminal under its own domestic law. I feel here that something is problematic for a variety of things, but I see the reason why you've done so. I understand the reason. I wonder whether there is a better way of doing it.
Thanks, Paola. Kai, would you like to share your thoughts?
Just on the previous point, there is another shortcoming with the ICC, and that is a lack of corporate responsibility. I mean, the fact is that the most important environmental criminals are multinational enterprises from our countries, and therefore I think we should have a much broader look at other initiatives. For example, the Business and Human Rights Initiative at the Human Rights Council, in the working group, where the word environment, I just skipped through it, comes up more than 10 times. So there are other options, transnational law, treaty-based crimes. I'm not so pessimistic as to state cooperation. International criminal law is much broader than core crimes and ICC. It existed long before the ICC. Think of the famous Schwarzenberger paper, The Different Crimes. We work in the European Union a lot with cooperation among states. So if we have efficient cooperation on environmental transnational prosecution, we have now the European Public Prosecutor, so there are other options. So that's just my general thought, that we should think much more openly and not be so focused on the ICC. As to the whole issue of balancing, I'm not of the view that criminal law does not allow for balancing, as for example, Darryl Robinson, who is among our participants and who wrote excellent posts on Opinion Juris, especially the second one I recommend you to read, because he brings up the several options to get rid or to solve the issue of the balancing. But criminal law and international criminal law too, of course, has elements of balancing. I mean, we have military necessity in war crimes. We have collateral damage. We allow for killing civilians. In national criminal law, we have necessity, cause of justification. So criminal law is not free from balancing. So again, that's a policy decision. And I totally understand if a group of distinct lawyers says we need to take account for social and economic benefits. I mean, that's just hypocritical to say, now we are the radical fundamentalist environmental people, and we do not allow, for example, to produce iPads or iPhones. We are violating and we are damaging the environment in this moment, in this very moment when we are in a Zoom conference. So it is just not realistic and credible to have a kind of a crime which does not take into account that there are socio-economic benefits. You mentioned Brazil, which I know very well. Of course, it's a legitimate interest for these countries to develop, and we cannot just come as Westerners and say, well, you should just criminalize this behavior. So that's for me not the issue. The issue is how you technically implement it, and I haven't problem with unlawful. I think it's just fragmentation. I agree with Paola, that would create a lot of fragmentation. It's a problem with principle of legality. But the problem with wanton is much more severe. Wanton is a term which is in criminal law, a term which was rejected, for example, by the American Law Institute when they did the model penal code, because it's such an imprecise term. You just read the definition, Philip, from your proposal, but that's not the general definition of wanton. We don't actually know what wanton means in criminal law. So that's why the American Law Institute took it out and uses intent and recklessness. And it is the old IHL term. It comes, that's one of these things we just take, it's a legacy. We take it from IHL. It was not written with criminal law in mind. And you don't need wanton to have the balancing in the actus reus. You can have the balancing in the first paragraph of Article 8 ter. You know, you just bring in this idea that we have to balance against certain benefits. That's it. That's the point. So the wanton thing is rather confusing, using a term which has a certain meaning, and therefore using also a term which has a certain subjective meaning. You know, it's depends. It comes to the mens rea. And another point I wanted to make, also having said Mr. Tilburger's question here, and another thing where we had you had received a lot of critique. That's the use of ecocide. When you say, Philippe, just now you said it's not genocide, of course. For various reasons, it's not genocide. And Christian Tomuschat at the ILC, when he was a rapporteur, he just used the word environmental crime. So I also made this point last week. I was not sure, why did you use ecocide? Is it just a selling point to sell it? And or why? Was there a more substantive reason, except that Raphael Lemkin is a great person? You worked on this, Philippe, and maybe you wanted to bring it in. Actually, you quote him in the draft. So that was another question I had to you.
Can I just come in with just 2 points in relation to this, because it's really interesting. And firstly, I'm really appreciating the conversation and all the comments. I mean, no one ever said it was easy. You can, listening to the conversation, I can imagine in 6 or 60 years' time, when the Assembly of State Parties actually negotiate this, you can just imagine people sitting around going through exactly these issues. And it's a very healthy debate. But 2 points. One, the corporate responsibility thing. That boat has sailed, okay? We were given a task as a group to come up with a definition to go into the ICC. That was the task we were given. That's what we engaged with. We didn't address whether there should be corporates or there should be a convention or this, that, or the other. That was just the premise, and that's what we went with. But I have to say, in relation to the corporate issue, I mean, my dear friend Andrew Clapham has been working powerfully for years on this issue, and I'm totally with him. But equally, as Louter Pact put in his closing speech for Hartley Shawcross in the summer of '46, states don't commit international crimes, individuals commit international crimes. And I have to say, I've had the experience of doing advices on crimes against humanity in relation to the corporate sector and the ICC in relation, for example, to the tobacco industry. I can tell you, the individuals who are associated with large corporations and small corporations, nothing concentrates the mind better than the possibility that they may be investigated or indicted for a crime, whether at the national or international level. And that is the way in. So at the end of the day, I'm actually not hugely in favor of going the corporate route. What are they going to do? You can't put a corporation in prison. you find the corporation a few million, they pay it off, it's 0.001% of their gross revenues, they don't give a toss, and they just carry on. The sound of bars clanking concentrates the mind. And that, I think, is more effective. On why ecocide, again, it's a really good question. And I have asked it many times. And of course, we can't take the definition of genocide because no one intends to destroy the environment in whole or in part. That's not how it works. People engage in other activities, and then the incidental, unintended, sometimes intended consequence, inadvertently, is massive damage to the environment. So you can't go with that. It's more a crimes against humanity approach. But this is really interesting. I said to Jojo Mehta, Stop Ecocide Foundation, I mean, why are you so obsessed with the term ecocide? She said, it's really interesting. We've done some market research on this. We've gone out on the streets. We've done polling. The moment you go and speak to people in the public, the grand public, and say, oh, we want environmental crimes against humanity or some such thing, eyes glaze over and what is that? And it's the same problem with crimes against humanity. It's a technical legal term. It doesn't excite the public imagination. If an American president says, oh, there's a crime against humanity taking place in X or Y country, no one cares. It's not in the newspapers. It doesn't make it anywhere. The moment an American president says genocide's happening here, it's on the front page of every newspaper in the world. And Jojo said, the moment you mention to those same people ecocide, everyone goes, oh yeah, well, I'm totally against that. That's a terrible thing. And so, yes, it's about marketing. And let's be clear, Lemkin got it absolutely right. Genocide is not the crime of crimes. It's not any worse to kill 100,000 people who are part of a group than it is to kill 100,000 individuals, in my view. But it attracts public attention in ways that technical legal terms simply do not. And part of this is, as I said at the outset, about changing public consciousness. And if that's what makes the public run, then a la Lemkin, I'm totally comfortable going with that.
You want to go next, Paola?
Yeah, but just quickly, because Philippe has mentioned this is linked to Kai's point about the using of the word ecocide. Maybe our listeners don't know that Lemkin was a linguist, of course, he knew many languages. And when he wanted to find a new name for the crime without the name, as Churchill called it, he said, I would like to find a name which is like Kodak. Kodak was just invented. And he wanted to have something that just clicks in your brain. And then he came with different proposal, and then he got genocide. And I think it was very successful because with this word, we convey a very powerful message. And I think that we can build upon this legacy, and having ecocide is much more, let's say, powerful, given this function of international criminal law also to put the red light, than environmental crimes that look so technical and they do not really have such powerful they don't touch the imagination of people. So I understand why you're obsessed with ecocide.
Thank you very much for this background explanation. And I found it really interesting to get to learn that there was actually some market research done. Perhaps the International Law Commission should also do that in the future to make their work more publicly accessible.
But also students when they find a title for their thesis.
Yeah. I mean, many titles are just very cumbersome and legalistic. So I think because we got a lot of questions on corporate responsibility, I would like to go with that for a couple of more minutes, because I personally, I'm not entirely sure if what you said, Philippe, is 100% true, that corporate officials get scared by the sound of bars, to quote you. But I have a feeling that often there is some sort of a corporate veil, and because people belong to a big corporation, an international enterprise, they're actually not so scared because they're just one little cogwheel in a big machinery. And it's often corporations which are deeply involved in the destruction of the environment. And perhaps, I don't know, Jorge or Paola, you have an opinion on that and want to join this?
Yeah, happy to say a few words on that. I think it's a dilemma. It's a dilemma because the issue, I mean, what is the real dilemma of trying to prevent the corporation from polluting the environment? And I agree entirely with Philippe that what concentrates the mind of someone who is at the top of a corporation is his or her risk personally. The problem is that even if they concentrate their minds and they have the other type of pressure, which is a pressure of being profitable, if something happens, the corporation can very easily shed just one guy or one top officer and continue doing what it does. So that would not necessarily tackle the issue. The other option is to tackle the corporation as such. But then the dilemma goes in the following way. The government itself that is in need to enforce in some way or another its own commitment to ecocide or a different type of environmental crime, will not necessarily want to make the innocent people working for the corporation pay, and also the sort of the socioeconomic benefits of the corporation existing. So we go back to the issue of the transaction and the externality. So you want to keep the corporation alive, just the good part of it. But by keeping the corporation alive, you're not able to keep the corporation alive just for the good part of it. Just imagine Royal Dutch Shell. I mean, it's the issue of climate change and the Milieu Defensie case. How do you go about that? How do you go about striking that line? And the simple question is this definition the tool that you're going to use to draw that line? I'm not sure this is a tool that you're going to use to draw that line. It serves a different function, which is to draw a much higher line. I mean, that's a Rome Statute. The Rome Statute is not about operational criminal law. So it's about symbolism. Now, if you really want to be serious about the empirical effect of a definition of ecocide, then you have to think about the afterlife of the definition of ecocide. And it's not the afterlife in the meaning of, is this going to be used to actually prosecute plenty of people at the ICC? Forget about that. I don't think that's, I mean, it may happen every once in a while, but what may really happen is that definition then is taken up plenty of times in domestic law. It is taken up potentially as a reflection of customary law. So it acquires a life of its own, which is really what makes possible that one day you will have a court in Canada, the Supreme Court of Canada, by the way, saying that you can ground a tort directly under customary international law. And what is the content of that tort? Well, suddenly you have something reliable. So you see, it's more about that type of afterlife where you find where you have to look for the empirical success of this definition, not at the level of the amendment.
I see that Professor Ambos has raised his hand.
Yeah, just on this very, very complicated issue of corporate responsibility, which has, again, different levels. First of all, as you know, the Business and Human Rights Draft Convention is not about criminal law. It's actually what we would call at the national level administrative law, or something which is pre-criminal law. So not necessarily we are talking about criminalizing multinational corporations. As you may know, in Germany, we don't even recognize as a kind of exceptional country in this sense the criminal responsibility for corporations for various doctrinal reasons. But on the other hand, it is not excluded that you have parallel prosecutions. I mean, what you do is of course, you prosecute the CEO, so the natural person, and at the same time you prosecute the corporation, and the actual impact on a person, on a CEO, and that's, I can tell you from experience here, for example, with Dieselgate in Germany, compared United States to Germany, is an efficient prosecution service. And that is what United States have. I mean, the maybe most efficient prosecution service is American federal prosecution, and every CEO will not even travel to the United States. You know that one of the managers of Volkswagen was 5 years ago arrested in the US because he made the mistake to make holiday, and they have done it very quickly. And while we are still here in Braunschweig, very close to Göttingen, with our prosecutor trying to prosecute Mr. Winterkorn, which is the main CEO of Volkswagen. So what I want to say here is, and that's experience from criminal law, you can have very nice criminal offenses in your code, in your books, all over the world we have it. I know many, many countries where they have the best criminal law offenses you can ever imagine, but there is corruption, there is no efficient prosecution, and then the CEOs will just laugh. I mean, they will, these are the multinational corporations which are much stronger than these countries. I mean, we have this problem to get the law enforced against Facebook, you know, which is in Ireland, you know, against Google. Why are they in Dublin? You know, I mean, so we need, of course, to address multinational corporations. But on the other hand, if we talk of deterrence, if we talk of real impact, we need efficient prosecution. And here, while I do not agree with Jorge that ICC is not operational, it's operational, but it's not at all efficient, you know, because the OTP has many, many problems. And you should really go out. That's what I said last week, Philippe and all the people of the group, go to the OTP right now, to our friend Khan, to the new chief prosecutor, and show him the Ecocide definition and ask him, what do you think? Make a meeting with them. Is this a thing we can do? Is this feasible for us to do it? We, in a realistic situation where we are as OTP, or are we not just over? The OTP is fighting all the time for more resources. As you know, in the Assembly of State Parties, Germany at front is limiting resources. So then we have maybe a counter effect. So we will do a disservice to Ecocide, to the environmental protection, because we create a crime which is poor symbolism. It's on the books, but in reality, it's not prosecuted. And that would be worse, I think.
Thank you very much for the passionate statement. I see Philippe perhaps wants to respond, and Paola has also raised her hand.
I don't know if I can take the advantage because I have to run to take my train, Philippe. And there is just one thing that I wanted to say when it comes to corporation and criminal responsibility of corporations, setting aside what Akai has correctly emphasized, that they may be powerful entities and therefore avoiding prosecution, but this is the case also with powerful people having money. I mean, it's something very complex, but I mean, there is one issue that I would like to underline. That setting aside for a moment the problem of the model you adopt for making legal entities as criminally responsible, whether or not you follow the French example, that you have to first identify also a human being acting on behalf of the company in order to make the company also criminally responsible, or you follow the US model where by way of evidence you shall find the responsibility, let's say by way of evidence of a human being acting on behalf of the company to make the company criminally responsible. So of course they have to act through individuals, these entities. I wanted to underline that a big problem, I think, in international law for making a corporation direct under the jurisdiction of an international tribunal, don't forget that corporations are not necessarily only private. Think of China. And how do you do with these public companies? If you assert the responsibility of corporations under international criminal law through the statute of the International Criminal Court or other international courts, such as the Malabo Protocol, then you make the exception for public companies, as they do, because otherwise the state would be affected, the state as such. Then I think it's totally crazy, because you can go after, I don't know, Amazon, but you cannot go after the Chinese enterprise. Is it something that we wanted, or are we ready to make also public companies subject to criminal punishment for environmental crimes? Otherwise, I don't know why we shall really be obsessed with only private companies. There are also bad guys which have public status in national and international law. That's I wanted to underline as an issue, in particular in environmental crimes, given the investments that China is making in Africa. So let's keep this with wide open.
Thank you very much, Paola. I think if Philippe is still ready to respond, I would give the floor to you.
I mean, it's not a substantive response, you know. It's really to Kai's last set of comments, because I think it really raises just fundamental questions about the nature of law. What's it for? What does it do? What does it do? What's its purpose? I'm not starry-eyed about law or international law. I don't for a moment believe the adoption of a crime of ecocide is suddenly going to bring people to heel any more than the crime of rape stops that despicable act, or the crime of genocide has stopped. It's just not how the world is. The law is one of the instruments that we have. It offers a powerful form of symbolism, and symbolisms can be incredibly important. I just want to be absolutely clear, Kai, that I'm not in any way making comparisons with what I'm about to say, okay? So please don't take this wrong. But as you were speaking, I was thinking back to all the debates that took place between 1935 and 1945, a really fascinating period when the architecture of the international criminal legal order was sort of constructed. And there was an extraordinary meeting in the summer of 1935 in Berlin, organized by someone you and I, Kai, will certainly agree is a despicable individual, Hans Frank, who invited a French academic, Henri Donnedieu de Vabre, to address the Deutsches Akademie für Recht. And de Vabre turned up, and he'd been thinking about this magnificent idea of an international criminal tribunal, and he gives the lecture. You've probably read the lecture, Kai and others. It's really interesting. And he sets out his ideas of why what the world would really be helpful for the world to have an international criminal tribunal to deal with terrorism and other horrible things. And Hans Frank was an educated, intelligent, and cultured guy, actually produces an interesting response. And he says, look, it's hopeless. I mean, here are 73 reasons why this is never going to happen, and we can't do it, and the world's not ready, and blah, 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 blah. And then 10 years later, and I often imagine the moment Frank leaves Frank is sitting there in the dock, and the door opens and the judges walk in, and there's Donnedieu de Vabre. And I've often wondered what happened when their eyes caught sight of each other at that moment. They both remember the dinner they had together in Berlin on that fine evening 10 years earlier, or had they both forgotten? I'm sure they hadn't. And I think there are moments when, yes, we've got to have the debates. Yes, we've got to realize there's all sorts of problems with what we're doing. Yes, there are better ways of dealing with it. But there's something else that's going on that is bigger. And that something else is going on right now. And it's in relation to the environment, where we have a major problem. And in this, my simple answer to Kai to all of your points is the generation of my children. They are deeply excited about this. They're not deeply excited about most of the other things I get up with. And I have to listen to that. They care about the environment. They worry about biodiversity. They worry about climate change. And to have me say to them, yes, of course you worry, but here are 17 technical legal reasons why this actually isn't going to work, or it's complicated, or it has all of these problems. Frankly, and I don't intend to be disrespectful, at the end of the day, none of that matters. The law is about symbolism, in part, and why this will happen. It won't be perfect. It will create lots of unintended consequences and problems exactly of the kind that you raise. But that's not a reason for doing it. And the heart of this debate really is about our social function as academics, as lawyers, as teachers, as judges, as counsel. What is it that we are engaged in? It's a very long game, and we're just at the beginning, and this minor tweak now shifts the boat in a different direction, and that's why, warts and all, I've come to support it.
Thank you very much, Philippe, for that passionate statement. It's the unfortunate role of a moderator to also have a look at the time. And because the discussion was so excellent, 90 minutes have almost already passed by. So by now, what we would suggest is first, our deep apologies that we couldn't answer all the questions which have been posted in the chat and the Q&A function. We received about 30 questions, which is just mind-blowing, and I will try to download all of them and send them to you, Philippe, afterwards, if you may be interested. But for now, we would like to invite all of you to give a brief, perhaps 2-3 minute closing statement. And we have thought it might be a good idea to provide you with a sort of open question relating to the title of our webinar, which is Ecocide, Legal Revolution, or Symbolism. And the question which we would pose is, on which side are you? What do you think? Is it more a legal revolution? Is it symbolism? Is it both? Something in between? And what is the potential of this new crime, the new definition? What is your take on that? And I think we should proceed in the following order because Paola has to catch a train. If she could go first, Professor Viñuales and Professor Ambos next, and Philippe, we would give you the last statement.
Well, I'll be very quick. I think it's a symbolic legal revolution, which is very much needed. I tend to agree with Philippe. I have a teenager as a daughter. She's 19, Philippe. And when I told her that I would have been joining this webinar on the crime of on the crime against environment and ecocide, she was super excited, like your children. And she really cares about her future, because we don't have a planet B. And whatever we could do as lawyers, as you said, as professors, to try to give an input to take this matter seriously into account for its great symbolic value, we need this legal revolution. So that's my view.
My turn, I guess. So very simply and very briefly, what I would say is this type of processes whereby there is a group that develops something, then there are many discussions. I mean, it's really a process that will continue, but this is as close as we lawyers get from fundamental research. We tend to think that lawyers don't do fundamental research, or we tend to do fundamental research in ways that sometimes I see as nonsensical. But I think that here we're doing, and the group has done, something very, very close to what in sciences would be fundamental research. We're trying to craft meaning and give that meaning a word, and then unleash that word with its meaning in the world to make an effect. So this is what we're trying to do. It will take time, but it's already deploying a quite powerful effect. So I can only look forward to what more it can do.
Yes, I think the great merit of this proposal is that it has sparked a discussion, and the interest shows in this webinar, the turnout also last week, that is a success in itself, and we have to congratulate the panelists and the members of this independent expert group. But as we all quoted our children, I could also quote one of my daughters, which does a doctor in law, and she asked me, and do you really think that criminal law will better protect the environment? So that's a counter question. So we cannot quote our children in a certain partial way. I mean, and that is really my concern. So I think we all agree that we have to better protect the environment. That's not the issue. You know, there was this lawyer's pledge to better protect the environment, and a colleague from Hong Kong wrote in each talk why I do not sign the lawyer's pledge. I don't think at all that we lawyers are better qualified or anything else to say these things. We have a certain function, and we should be professional, we should be serious in our work, but I don't think that we have more legitimacy. And the issue for me, and perhaps that's a bit the issue with the Germans here, and therefore I'm a bit playing the devil's advocate here, you know, we don't like these things which are more perhaps made with marketing in place and so in mind. And so Philippe actually confirmed my concerns when I wrote the blog. I didn't write this because I didn't know. I couldn't speculate that that was a reason, but Philippe was very honest. I mean, Philippe was very honest. And when you look at the Stop Ecocide Foundation website, the new one, it's full of errors in terms of jurisdiction, for example. It speaks of universal jurisdiction of the ICC, and I sent this to Charles Cello and to Kat, and really distanced themselves. They said that's not our website. That's the Stop Ecocide Foundation. That's not us as a group. So that's just an NGO. But here we have a problem. Then, when does it turn into something which may do a disservice? That's a bit my concern. But of course, I congratulate you all on this work. Thanks.
I say bye-bye to Paola before she goes.
Thank you very much for having been here, Paola. It was a pleasure.
Thank you very much. Thank you. Bye. Good evening.
Bye-bye. And now over to you, Philippe.
Yeah, no, can I firstly thank all the panelists. I mean, you know, we're all in this spirit together. Symbolism or revolution, it's not either or, it's both. I mean, you can ask the same question of what Pact and Lem were up to in 1945. Did they change the world? Some people say yes, some people will take Kai's position and say it hasn't made the blindest bit of difference, the invention of those two concepts. And is the glass half full or is it half empty? It's a classical issue that we all address. It's not symbolism or revolution. I think it's both, as it was, you know, for those characters back in 1945. You know, I'm just finishing making a BBC Radio 4 program on the 75th anniversary of Nuremberg. What's its legacy? And I've posed a lot of the questions that Kai has posed. You know, some people thought it changed the world. Others say, maybe like your daughter, Kai, actually, what did it really do? Who did it really protect? Is there any evidence? You know, you like evidence, Kai. Is there any evidence that the invention of these crimes has stopped a single crime from being committed? I'm often asked that, and I'm unable to give an answer. I can say the existence of these crimes has stopped people traveling. We know that. And so that may or may not be a good thing. But I think at the end of the day, I remember, you know, making that radio program, I spoke last week to Ben Ferencz, aged 101. And he described to me what a pain in the ass Raphael Lemkin was. He'd come to them, he'd lobby them, he said he was a total distraction. We were just prosecutors trying to get on with our job, and along came this disheveled old character irritating us, genocide this, genocide that. And we, you know, listened to him politely and we shooed him off. And but he got it through, and maybe it made a difference. And I think this is just exactly the same kind of a situation. And I think no one here is more right or more wrong. These are all reasonable views. But the bottom line is it's happening. I get invitations privately to address ministers, to address EU commissioners, to address prime ministers, to address presidents. They want to know all about this, what they should be doing about it. It's happening. So I would urge those who have a critique, and a valid and legitimate critique, perhaps not to put their efforts into stopping what is the inevitable, but rather their formidable intellectual capacities into limiting the damage, making it as good as it could possibly be in the circumstances in which we find ourselves, because it's plainly happening. And that's, I think, the boat we should hitch our sail to. But I've listened with real pleasure, and I express my thanks to Romina and Jan-Phillip for organizing this, and of course to Jorge and Kai and Paola, and for everyone who's been on. We're all struggling, I think, in the same waters, on the same boat, to try to do the right thing and reasonable people will disagree.
Thank you so much to all of you for these closing statements, and also for accepting the invitation, for being here, and also to the audience for participating in the webinar. And I think that all of us can agree that this is inviting us to think out of the box about a possible solution, in the sense which could be a criminal consequence, or which will be the legal consequences for harming the environment from a criminal perspective. And we think that for sure this draft definition is a good starting point, and the amount of debates and that it has been taking place, it's a good evidence of that we are moving in the good way of our path. So for our side, from Jan-Phillip and from myself, I think that our 2 cents to the Ecocide definition is to create this virtual space to discuss about it, and we are super helpful and thankful for this.
But as also the renowned Chilean professor and later judge at the ICJ, Alejandro Alvarez, once said in his speech before the Grotius Society in 1929, and I quite like this quote in relation to the Stop Ecocide campaign, quote, "Many projects at first looked upon foolhardy or utopian have been a little later, as a result of certain events or circumstances, been considered very acceptable." And just to give you one example, this year we commemorated the passing of the exceptional James Crawford. One of his arguably biggest achievements, among so many others, was the successful completion of the draft articles on responsibility of states for internationally wrongful acts in 2001 as the ILC's special rapporteur on this topic. But we should remember that the work for this milestone began in 1949 with the selection of this topic by the first ILC, and took the work and dedication of 4 other special rapporteurs until James brought it to completion. In this vein, we would like to thank our panelists for making such a lively academic discussion possible. We would also like to thank the IFHV, the Graded Institute, and ESIL for their support. And last, but certainly not least, we would like to thank you, the audience, for attending this event, and we hope that you have found some inspiration in the never-ending pursuit of international justice. Thank you very much for your attention, and have a good evening. That would be it from our side.